You have been chosen.
All right, let's get it popping. Clifford Bey back at it again, helping you to understand the criminal courts of New York. All right. Now, you're not going to understand this video if you don't understand how to maintain your sovereignty. Now, please go watch that video before you watch this video. Thank you very much. All right, let's proceed. Now, in order for the courts, right? Let's start with the lower courts. Let's start off real simple, right? You got in order for the courts to have jurisdiction over you, they need to have personal jurisdiction, right? And then they need to have I guess geographical jurisdiction, right? And then jurisdiction of the subject matter. Now, they might could have jurisdiction of the subject matter, right? If the law is applicable. But most of the times, if there's not a injured party involved, they're gonna like personal jurisdiction and they're gonna like geographical jurisdiction. All right. So let's get to it. Applicability, right? In the state of New York, all accusatory instruments must be entitled the people of the state of New York, right? Now, with that being said, we already know in the criminal courts, all the criminal courts are legislative courts, right? So they courts, right, are not going to be titled as such, right? They courts are going to be under the jurisdiction of this state, which means New York State with a capital S. And we already know that means a district state, right? And all these counties, they're going to say you committed a crime in such and such county or something like that, right? And even the county, right, is under the jurisdiction of this state, which is a district state, right? Which district states have legislative courts and not judicial courts. All right, per O'Donoghue, we already know this. And under Title 28, USC Section 1604, foreign states have immunity from the district courts, from the United States courts, and from the courts of the United States and of the states, which are the district states, right? Foreign states have immunity. So we have immunities from these courts, and we got to raise that issue, right? But let's talk about the defectiveness, right? So if it's a traffic ticket, it's going to say, right? If it's a traffic ticket, the accusatory instrument is going to be the capital S, right? Capital T, capital P of the capital S state of New York, right? Now that's defective. And now I'm about to show you how you could motion when you see that defect, all right? Indictments as well is going to be defective if there's no injured party. Even if there's an injured party, it could still be defective because they like to put everybody under the jurisdiction of the district state. So even if there's an injured party, when you see a defect, you gotta call it out, right? Motion, hey, fuck it. You feel me? Damn. Not to teach people how to be criminals and all that, but they could easily change that defect and then get you if you really did commit a crime. But if you didn't really commit a crime, if you for instance, violated a statute which don't apply to you, right? Then yeah, they can't easily fix that, right? Defect. But if you did violate it, injure somebody, then yeah, they could fix that defect and then bring you under the geographical jurisdiction of the union state. I believe they definitely can do that. All right, but yeah, let's get it. So I'm gonna teach you how to file a motion, right? Now, first thing you want to know. Let's start with the definitions, all right? We got to start with the definitions. So I'm gonna help you understand what's really going on. So let's define court, right? Or who's prohibited from using the word court. All right. So New York, right? Judiciary law section, right? So use of term court prohibited, right? No person, firm, association, or corporation shall hereafter use or employ the term court as part of or in connection with the name of any body, board, bureau, association, organization, or corporation, or in referring to any body, board, bureau, association, organization, or corporation in such manner as to be calculated reasonably to lead to the belief that the body, board, bureau, association, organization, or corporation is vested with judicial power or is a part of the judicial system of the state. The use of such term being especially limited by this section for reference to a court of record or a court not of record duly organized and existing under the laws of the state as a part of the judicial system of the state. Right? So let's break it down. Let's break it down now, because let's look at the term arraignment, right? Let's go to the definition of arraignment. So when you go to your arraignment, right? This is what arraignment means. Means the occasion upon which a defendant against who an accusatory instrument has been filed appears before the court, right? Now we know what the definition of court means, a judicial proceeding, right? In which the criminal action is pending for the purpose of having such court acquired and exercise control over his person with respect to such accusatory instrument and of setting the course of further proceedings and the action. Now, when it's the state of and the capital S, right? We know, no, well, yeah, in the state of New York, we know they in violation of judiciary law, section 3, and it's not really an arraignment. Because an arraignment, right, is when a defendant appears before the court. But we know courts are of judicial proceedings, not legislative, right? So let's continue. Let's go to judge. Means any judicial officer who is a member of or constitutes a court. Not in the state of New York, they don't. Whether referred to in another provision of law as a justice or by any other title. So they got to constitute a court, right? It got to be a judicial officer. A judicial officer is one of judicial function, which we know these criminal courts of New York are not of judicial function. So these judges aren't judges. When it comes to the criminal courts, now for civil matters, they status change, but we can always get them in criminal courts, right? Because in order to be a judge, right, it gotta be a member of or any judicial, or it gotta be a judicial officer who is a member of or constitutes a court, right? But in order to be of a court, you gotta be of a judicial function. Ah, got him. All right. Continue. All right. All right. So now that we got that understood, I'm gonna help you understand some more legal definitions, right? So let's go right here, right? Right here. Legal proceeding means a proceeding in or before any court. Now we know these courts are not of a judicial function, so they are not courts or grand jury or before any body, agency, or person authorized by law to conduct the same and to administer the oath or to cause it to be administered. Now, since uh, legal proceeding means a proceeding in or before any court, right, or grand jury, right, authorized by law. Now, in order to be authorized by law, you got to be authorized under judiciary law, section 3, right? Or you can't use the word court. So technically, right, the criminal courts are holding unauthorized legal proceedings, which is not authorized by law, right? Gotta know that. All right, let's continue. Moving forward. All right, let's go to grand jury now, right? Let's go to the grand jury. Bang, the grand jury and its proceedings, right? All right, 190.05 grand jury definitions and general functions. A grand jury is a body consisting of not less than 16 nor more than 23 persons and paneled by a superior court. It got to be a court, right? And constituting a part of such court, the functions of which are to hear and examine evidence concerning offenses and concerning misconduct, nonfeasance, and neglect in public office, whether criminal or otherwise, and to take action with respect to such evidence as provided in section 190.60 of this. All right, grand jury for what courts drawn? The appellate division of each judicial department. In order to be a judicial department, you got to be of a judicial function. None of the criminal courts are of a judicial function, so they don't have judicial departments. All right, shall adopt rules governing the number and the terms for which grand juries shall be drawn in a panel by the superior courts. So technically, if you are under the criminal courts in New York and they impanel a grand jury, that means that grand jury was unconstitutionally impaneled and not authorized by law to have legal proceedings within the meaning of, you could cite the section, right? So it will be within the meaning, right? The grand juries doesn't meet the requirements of section 190.5, point zero 05, right? And there are, and damn. All right, 1 second. Anyway, y'all gonna have to put it together, even though I already did, but I'm just showing y'all how y'all could skate through this. I'm gonna do the best I can for y'all. All right, so we already know, right? So when you are citing the definition of legal proceeding, or when you are saying these people are not judges, you could say this person is not a judge within the meaning, then cite the the criminal procedure law definition, right? That states, that gives the definition of judge and how it applies to someone of a court. Same way as grand jury, right? So a grand jury of the criminal court doesn't meet the requirements of this section. So you could cite it that the grand jury is defective because it does not meet the requirements of this section, by impaneling uh, a grand jury that's not authorized by a judicial court. Or, I mean, y'all could express it. Y'all know what I'm talking about. Then again, maybe not. But, the smart ones know what I mean. And if you don't know what I mean, you can easily get a consultation. All right. Moving forward. So let's go to proceedings, right? So, indictment, right? Definition of indictment. An indictment is a written accusation by a grand jury filed with a superior court, filed with a superior court, charging a person. But anyway, let's get to it. So, with that being said, if the grand jury is defective, that means the indictment is defective, right? An indictment is a written accusation by a grand jury. But if the grand jury is defective, that means the indictment is defective. All right? So that's what you need to know. And we know all the criminal courts indictments are defective. That's crazy. Like, that's crazy. All right, let's continue. Uh, Bang, right? We gonna get out of this real quick. Oh, nah, proceedings. All right, let's go to proceedings and city courts before we do supreme and county courts. All right. So proceedings in local court, right? Instead of the superior courts. So commencement of action and local criminal courts. All right. So all right. So it's giving all the definitions and all that, but I'm gonna show you how you could what you gotta do to motion to dismiss or challenge it. All right. That's what I'm doing right now. All right. So information, misdemeanor complaint, and felony complaint. Form and content, right? An information, a misdemeanor complaint, and a felony complaint must each specify the name of the court, which we know they are not courts, with which it is filed, and the title of the action. It must be subscribed and verified by a person known as the complainant, right? The complainant may be any person having knowledge, whether personal or upon information and belief, of the commission of the offense or offenses charged. Each instrument must contain an accusatory part and a factual part. The complainant's verification of the instrument is deemed to apply only to the factual part thereof and not to the accusatory part, right? So let's keep going, right? The accusatory part of each instrument must designate the offense or offenses charged, right? As in cases of an indictment and subject to the rules of joinder applicable to indictments two or more. Also, in the case of an indictment, hold on now. All right. The factual part of such instrument must contain a statement of the complaint alleging facts of an evidentiary character supporting or tending to support the charges, where more than one offense is charged. The factual part should consist of a single factual account applicable to all the counts of the accusatory parts. The factual allegations may be based either upon personal knowledge of the complaint or upon information and belief. Nothing contained in this section, however, limits or affects the requirements prescribed in subdivision 1 of section 1.40, that in order for an information or account thereof to be sufficient on its face, every element of the offense charge and the defendant's commission thereof must be supported by non-hearsay allegations of such information and or supporting depositions, right? And I will try to further explain this, and we'll go to this section to see what it really says, all right? All right, so right here we got where felony complaint charges a violent felony offense defined in section 70 of the penal law and such offenses and armed. All right, now we ain't got to do that. Supporting deposition, definition, forms, and content. A supporting deposition is a written instrument. All right, nope. And defendant's rights to supporting deposition notice requirements. All right, we ain't gonna get to that, right? All right, we ain't gonna get to that. And I advise y'all to read this. Like, always read the criminal procedure laws. You know, you gotta study. Don't just watch my video and think you know it all, cause nah, that ain't it. But I'ma at least give you key elements. You know, that's the best I could do. All right, where's that? Where's that? All right, local criminal court accusatory instrument sufficiency on its face. Information or account thereof is sufficient on its face when it substantially conforms to the requirements prescribed in section 1.15 and the allegations of the factual part of the information together with those of any supporting depositions which may accompany it provide reasonable cause to believe that the defendant committed the offense charge and accusatory instrument and the accusatory part of the information and non-hearsay allegations of the factual part of the information and or of any supporting depositions established if true every element of the offense charge and the defendant's commission thereof. Right, I'm gonna try to explain that the best way I can. All right. All right, so simplified information is sufficient on its face when as provided by subdivision 1 of section 1.25. It substantially conforms to the requirements therefore prescribed by or pursuant to law, right? Provided that when the filing of a supporting deposition is ordered by the court, pursuant to, but all right, so here's the thing, right? We getting into the actual allegations on the accusatory instrument. And we could fight that, but that's you fighting that if you're already moving forward in the case and you already submitted to the jurisdiction, right? That's when all this comes into play. But the instrument itself, right? If it's going to be the capital S, you ain't really got to worry about this because now you're challenging the court's jurisdiction to even hear the case. It's not even about the facts of the case. It's not about none of that. It's about whether the court has the authority to even hear the case. And they're not even a court, not in the criminal courts. They're not even considered courts. They're legislative courts. So they don't have the authority to even hear such case, right? So let's go to that. Let's go to, how we could dismiss that, right? So right here, let's keep going. Let's keep going. Oh, nope. That's not even that. Damn. I'm in the wrong part. All right, proceedings. I believe it's in proceedings. Damn. What the hell? Motion to dismiss, right? Information. So, right, you got motion to dismiss information, simplify information, prosecutor's information or misdemeanor complaint, right? And then you got motion to dismiss information, simplify information, prosecutor's information or misdemeanor information complaint as defective. That's what you want to do. And you also want to add this in furtherance of justice. This might will give them a way out, but I don't think they never take that way out. And then it's procedures regarding the motions, right? And then you got motion and superior court to dismiss prosecutor's information, right? So let's go to that real quick. Motion to dismiss information. All right, motion to dismiss information, right? So after arraignment, which we know all the arraignments are illegal because if it got the capital S, it's not really an arraignment within the meaning of the definition given. An arraignment in the meaning of the definition given is for a court, which is of judicial function, right? So anyway, after arraignment upon information, a simplified information, a prosecutor's information, or a misdemeanor complaint, the local criminal court may, upon motion of the defendant, dismiss such instrument or any count thereof upon the ground that it is defective within the meaning of section 170.35, or the defendant has received immunity from prosecution for the offenses charged pursuant to sections 50.20 or 190. We ain't got to worry about that. The prosecution is barred from reason of a previous prosecution pursuant to section 40. Nope, we ain't got to worry about that. The prosecution is untimely. Nope, we ain't got to worry about that. The defendant has been denied the right to. We ain't got to worry about that. There exists some other jurisdictional or legal impediment to conviction of the defendant for the offense charge. All right? Yeah, we could cite that as well as A. Right? We also cite G, right? Dismissals required in furtherance of justice within the meaning of because we going to get into that, right? So let's go down to, should I read this? Let me see if a motion pursuant to this section except a motion pursuant to paragraph E of subdivision 1 shall be made within a period provided by section 255.20. A motion made pursuant to paragraph E of, they talking about trials, I believe, right? Upon a motion, a defendant who is in a position adequately to raise more than one ground in support thereof shall raise every such ground upon which he intends to challenge the accusatory instrument. Every, right? A subsequent motion based upon such a ground not so raised may be summarily denied, although the court, in the interest of justice and for good cause shown, may in its discretion entertain and dispose of such a motion on the merits notwithstanding. All right, so let's get down here, right? Motion to dismiss information, simplify information, prosecutor's information, or misdemeanor complaint as defective. You always want a motion to dismiss as defective if it got the capital S, right? The accusatory instrument is defective. All right, an information, a simplified information, a prosecutor's information, or a misdemeanor complaint, or account thereof is defective within the meaning of paragraph A of subdivision 1 of section 10.30 when it is not sufficient on its face pursuant to the requirements of section 100.40, right? Provided that such an instrument or account may not be dismissed as defective, but must instead be amended, where the defect or irregularity is of a kind that may be cured by amendment, and where the people move to so amend, or the allegations demonstrated that the court does not have jurisdiction of the offense charge, right? So it's defective if the allegations demonstrated that the court does not have jurisdiction of the offense. Now, the offense is different from uh, actual, how should I say? They might have the offense is subject matter, right? So if they got jurisdiction of subject matter, they got jurisdiction of the offense, right? The statute defining the offense charge is unconstitutional or otherwise invalid. So if they trying to subject you to uh, uh, a definition that's only applicable to the district states, right? The statute defining the offense charge is unconstitutional or otherwise invalid, right? because these misnomers don't apply to you. And information is also defective when it is filed in replacement of a misdemeanor complaint pursuant to Section 170.65, but without satisfying the requirements stated therein. So we got to figure out what that is. A prosecutor's information is also defective when it is filed at the direction of a grand jury pursuant to Section 190.70, and the offense or offenses charged are not among those authorized by such grand jury direction. So that means, after the grand jury then gave their direction, the prosecutor added more stuff to it. Yeah, I don't know how that happens, but anyway. So that's A, right? And then B, it is filed by the district attorney at his own instance, pursuant to subdivision 2 of section 1.50, and the factual allegations of the original information underlying it and any supporting depositions are not legally sufficient to support the charge and the prosecutor's information, right? So if they talking about you committed a crime, right, and which the statute is invalid, it's not applicable to you because it's unconstitutional. It will be unconstitutional if they applied it to you, right? Then the prosecutor's information will also be defective, right? If it is filed by the prosecutor and the factual allegations of the information underlying it and supporting the offense, right? So any facts supporting the offense will also be not legally sufficient, because if you're getting charged by something that's not applicable to you, that means the person that is trying to say you committed such offense is also will be invalid, because the law that they're saying that's applicable to you is not valid. So whatever they're saying is not applicable. I hope that makes sense. All right. So let's not move forward. Let's see what's that 140. Let's see where that's at real quick, right? Oh no. Instead of doing that, we're gonna go back up here and we're gonna just pop open another tab real quick, right? And I believe that will be under Article A, right? 1. Oh no, it's at 100. So I'm bugging. All right, 100.140. Arrest without a warrant. All right. So let's go back down here real quick. All right, as defective. So 100.40. All right. Oh, now I'm tweaking. There we go. That's right here. 100.40. All right, so let's go all the way to 40, right? Local criminal court accusatory instrument sufficient on its face. And information or account thereof is sufficient on its face when it substantially conforms to the requirements prescribed in section 1.15, and the allegations of the factual part of the information, together with those of any supporting depositions which may accompany it, provide reasonable cause to believe that the defendant committed the offense charged in the accusatory part of the information, and non-hearsay allegations of the factual part of the information, and or of any supporting depositions establish, if true, every element of the offense charged in the defendant's commission thereof, right? So it gotta be non-hearsay, right? And it gotta meet the requirements of 115. So, let's see. Let's go to 115, right? An information, a misdemeanor complaint, or a felony complaint must each specify the name of the court within it is filed and the title of the action. It must be subscribed and verified by a person known as the complainant. The complainant may be any person having knowledge, whether personal or upon information and belief of the commission of the offense or offenses charged. Each instrument must contain an accusatory part and a factual part. The complaint's verification of the instrument is deemed to apply only to the factual part thereof and not to the accusatory part. All right. And to the accusatory part of the offense, I think I read this already. What the hell, man? Anyway, so we already know information, right? A misdemeanor complaint and a felony complaint must each specify the name of the court. So look, even right here, it must name a court. But we already know, this term court cannot be used unless it's of a judicial function. It must name a court. And we know, these uh these criminal courts are not courts within the meaning of Judiciary Law, Section 3, right? So the instrument is defective because the information, in order for the information, misdemeanor complaint and felony complaint form and content to be valid or 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 how I say lawful, right? It must name a court, and in order for them to name a court, or use the term court, they got to be under the jurisdiction of a judicial court system or judicial branch, Article 3 court, which none of these criminal courts are. They're not under judicial authority. They're under legislative authority, right? So right here, it's defective. So it doesn't meet the requirements of 115 because they must name a court. I hope you understand that. Shit, that's something new. Even though it's not new, but that really just came to mind right there. Yeah. All right. So anyway, let's continue, man. So we already know, right? So it's defective because it is not sufficient on its face, right? Pursuant to the requirements of section 140, right? We know that the allegations demonstrated that the court does not have jurisdiction of the offense, right? Yeah, they don't have jurisdiction. Oh no, of the offense. Yeah, they probably got jurisdiction of the offense, right? Well, we got this. So as long as we get A, right, we could get it off of just A. The statute defining the offense charges unconstitutional. We could get it off of A and C. Yep, A and C. So it's defective, right? Pursuant to A and C, right? That's all we could get them. All right, so let's see, 150, right? A prosecutor, right? We already know a prosecutor's information is also defective when it is filed at the direction of a grand jury. But if the grand jury is defective, yeah, we could get them for that too. But we gonna get later. We gonna show you how to file a dismiss information of a defective grand jury because you guys cite that as well. All right. All right. But anyway, yeah, we could get them for this right here. It's defective off of 1A and C, right? The charge is unconstitutional or otherwise invalid, the statute. And most of these statutes that they try to, like, for instance, traffic tickets, right? We could use this, right? Or any federal statutes that don't apply to how should I say, any federal statutes that don't apply, that's not applicable to the Union states. We could get them for. Yeah, right? The statute defining the offense charge is unconstitutional or otherwise invalid for a person of a foreign state. Yeah, we could get them for that as well, right? And then, right, motion to dismiss information, simplify traffic information, prosecutor's information, or misdemeanor complaint and furtherance of justice, right? So, right, this is what it says. An information, a simplified traffic information, a prosecutor's information, or a misdemeanor complaint, or any count thereof may be dismissed in the interest of justice as provided in paragraph G of subdivision 1 of section 170.30 when, even though there may be no basis for dismissal as a matter of law upon any ground specified in paragraph A through F of said subdivision of section 170.30, such dismissal is required as a matter of judicial discretion by the existence of some compelling factor, consider or circumstances clearly demonstrating that conviction or prosecution of the defendant upon such accusatory instrument or count will constitute or result in injustice. Right? So this is how we could give them a way out. But then again, nah, we on their next full throttle. We don't want to give them a way out. But, this will definitely give them a way out if you file a motion pursuant to and furtherance of justice, right? Because they could just say, they could leave out anything, any motions you file A through F and just say that, oh, we're gonna dismiss your case pursuant to 170.40, section G, I believe, which is 170.30. Hold on, is this? Yeah, 170.30 G, paragraph G, right? Which is dismissal and furtherance of in the interest and furtherance of justice. I mean, tripping over my words. All right. Anyway, let's continue. So this is the procedures, right? Motion to dismiss information, simplify traffic information, prosecutor's information or misdemeanor complaint. Procedure. The procedure rules prescribed in section 210.45 with respect to the making, consideration, and disposition of a motion to dismiss an indictment are also applicable to a motion to dismiss an information, a simplified traffic information, a prosecutor's information, or a misdemeanor complaint. Right? So we got to know how to proceed in dismissing a motion, right? And they lay that out under this section, which is applicable to the local courts and the superior and county courts, right? All right, so now let's go to the grand jury, right? Because these right here, the local courts is for non-felony charges and traffic infractions and all that. Now we're gonna go to the felony charges, right? Which you got to go through a grand jury, all right? You got to go through a grand jury. So let's motion and superior court to dismiss prosecutor's information. All right. All right. Anyway, we're gonna go back, right? Because they try to at any time after arraignment in a local criminal court upon a prosecutor's information filed at the direction of a grand jury and before entry of a plea of guilty thereto or commencement of a trial thereof, the local criminal court, when a prosecutor's information is filed, may, upon motion of the defendant, dismiss such prosecutor's information or account thereof upon the ground that the evidence before the grand jury was not legally sufficient to support the charge. Well, this is how you can file a motion in a local criminal court. All right, but y'all can read more on that. I'm just trying to show y'all the defects in the criminal court system. and give you the laws and the procedures, give you the procedures and some law to apply when you filing your motion to dismiss. All right, so now let's go back to the grand jury, right? So when you get in the rain, right, lawyers, what they like to do, they like to make you miss your opportunity to be heard in a grand jury, right? But however, if you fire your lawyer, right, this is what they gotta do, right? You could do this. All right, so all right, let's see. Grand jury rules of evidence. Nope, not that. Let's go down. Nope, not videotape. All right, grand jury witnesses, compulsion of evidence and immunity. All right, every witness in a grand jury proceeding must give any evidence legally requested of him, regardless of any protest or belief on his part that it may tend to incriminate him. Right? A witness who gives evidence in a grand jury proceeding receives immunity unless he has effectively waived such immunity pursuant to Section 190.45, or such evidence is not responsive to any inquiry and is gratuitous, whatever that word means. You know, sometimes I got a speech impediment, so excuse me. Grat, grat, gratuitously given or volunteered by a witness with knowledge that it is not responsive. All right, all right. So let's go further. Waiver of immunity. Nah, we go past that. All right, who may call witnesses, defendant as witness, except as provided in this section. No person has a right to call a witness or appear as a witness in a grand jury proceeding. The people may call as a witness in a grand jury proceeding any person believed by the district attorney to possess relevant information or knowledge. The grand jury may cause to be called as a witness any person believed by it to possess relevant information or knowledge. If the grand jury desires to hear any such witnesses who was not called by the people, it may direct the district attorney to issue and serve a subpoena upon such witness, and the district attorney must comply with such direction, right? At any time after such a direction, however, or at any time after the service of a subpoena pursuant to such a direction and before the return date thereof, the people may apply to the court which impaneled the grand jury for an order vacating or modifying such direction or subpoena on the ground that such is in the public interest. Upon such application, the court may, in its discretion, vacate the direction or subpoena, attach reasonable conditions thereto, or make other appropriate qualifications thereof. Right? So, notwithstanding the provisions of Division 3, the district attorney may demand that any witness thus called at the instance of the grand jury sign a waiver of immunity pursuant to Section 190.45 before being sworn, and upon such demand, no oath may be administered to such witness unless and until he complies therewith. All right. All right. Anyway, let's continue. All right. Oh, man. All right. So, a defendant or person against whom a criminal charge is being or is about to be brought in a grand jury proceeding may request the grand jury, either orally or in writing, to cause a person designated by him to be called as a witness in such proceeding. The grand jury may, as a matter of discretion, grant such request and cause such witness to be called pursuant to subdivision. All right. So let's go. All right, here we go. All right. So grand jury who may call witnesses, defendant as witness. Right. And we go down to 5. Although not called as a witness by the people or at the instance of the grand jury, a person has a right to be a witness in a grand jury proceeding under circumstances prescribed in this subdivision. When a criminal charge against a person is being or is about to be or has been submitted to a grand jury, such person has a right to appear before such grand jury as a witness in his own behalf. If, prior to the filing of any indictment or any direction to file prosecutor's information in the matter, he serves upon the district attorney of the county a written notice making such requests and stating an address to which communications may be sent. All right? So, you got locked up, now you got out, and the lawyer done gave you documents, right? The court done gave you documents stating that a grand jury proceeding is going to proceed on such and such date, right? Now you can request that you can either tell your lawyer that you want to be there, or if you ain't got a lawyer, I mean, if you're doing shit like this, excuse my French, if you're doing processes like this, you ain't gonna have no lawyer. You feel me? So you gonna write it yourself, right? You gonna write that letter to the district attorney, letting them know that you want to be present at that hearing, right? So, with that being said, let's continue, right? All right. When a criminal charge against a person is being or is about to be or has been submitted to a grand jury, such person has a right to appear before such grand jury as a witness in his own behalf if, prior to the filing of an indictment or any direction to file prosecutor's information in the matter, he serves upon the district attorney of the county a written notice making such request and stating an address to which communications may be sent. The district attorney is not obliged to inform such a person that such a grand jury proceeding against him is pending, right? So, in progress or about to occur, unless such person is a defendant who has been arraigned in a local criminal court upon a currently undisposed of felony complaint charging an offense which is a subject of the prospective or pending grand jury, so a pending grand jury proceeding, right? So a district attorney ain't got to tell you nothing unless you've been arraigned already. I guess that's what they're saying. After you have been arraigned, right? They're gonna give you documents, and they're gonna give you a document showing, letting you know that there's a pending grand jury proceeding pending against you. Now you got to write and let them know, like, listen, I want to be here at this grand jury, right? If you're still locked up, you gotta let your lawyer know, all right? Or if you're representing yourself while you're locked up, then you feel me? You got to find a way. In such case, the district attorney must notify the defendant or his attorney of the prospective or pending grand jury proceeding and accord the defendant a reasonable time to exercise his right to appear as a witness therein. Right? Upon upon serve upon service upon the district attorney of a notice requesting appearance, right? Notice requesting appearance before a grand jury pursuant to paragraph A, the district attorney must notify the foreman of the grand jury of such request and must subsequently serve upon the applicant at the address specified by him a notice that he will be heard by the grand jury at a given time and place. Upon appearing at such time and place, and upon signing and submitting to the grand jury a waiver of immunity pursuant to Section 190.45, such person must be permitted to testify before the grand jury and to give any relevant and competent evidence concerning the case under consideration. Upon giving such evidence, he is subject to the examination by the people. Now, this is where it gets fun at, right? I wish I would have did this. Now, say for instance, you do go to this grand jury, right? And you give evidence of law proving that you're immune to these criminal courts or whatnot, right? Now, what could make it really interesting is you could give them an example of how their grand jury proceeding is defective, and that each and every one of them, if they choose to find you guilty, they will be considered operating under the color of law. And then you could get the transcript there giving them, showing that you gave them due process of them, or you gave them notice of them and evidence that they was operating under the color of law, and they still choose to proceed and indict you and issuing a defective indictment. Yeah, fuck it. Why not? Get the whole grand jury. Oh, y'all want to play? Yeah. We gonna get all y'all motherfuckers. You feel me? Kick all y'all motherfuckers off the block. That's gonna make the grand jury. I think by showing them the difference between foreign states and letting them know how, you know, letting them know, showing them the accusatory instrument, or the instrument that subpoenaed the defendant to the grand jury, showing them everything, how, the caption says the state in all capitals and not lowercase, and how it's defective pursuant to accusatory instruments. Man, that might scare the grand jury. I ain't even gonna lie. Like, that's funny. All right, but let's continue. Let's continue. So, right? You gotta request. You gotta be quick about it because you only got like 5 days, to give that request. So as soon as you get out of jail from that arraignment, write that letter, man. Like they only give you like 5 days, I think. Let me see. Here's the request. All right. Let me see. Right. All right. Anyway, let's continue. Let's see how the motion. So we already got this, right? So this is how you could request for to be at your hearing at the grand jury that's already defective, right? All right, let's continue. Now let's go to motions and the superior courts. Uh, okay, go there. Now we want to go to prosecution of indictments, right? All right. Pre-trial motions. All right. You know what? Nah, that's not even this. Let me go back to this title, right? Anyway, nah. All right, yeah. Proceedings in Superior Court, all right? We're going to go ahead. Indictment and related instruments, right? Oh, no, proceedings in Superior Court from filing indictment to plea. Not, what is it? All right. Adjournment and contemplation of dismissal for purposes of referring. Oh, no, is it this one? All right, let me see. Nope, not that. All right. Nope, not that. Well, I guess it is this. All right, pretrial motions, right? All right. So pretrial motions is any motions before a trial, to make it short. And that's what it says, right? Except as otherwise expressly provided by law, whether the defendant is represented by counsel or elects to proceed pro se, you never want to proceed pro se. You want to proceed in propria persona or an Yeah, in propria persona, never pro se. Well, dang, I should have explained that in my other video as well. But anyway, let's get to it. So you always want to proceed in propria persona, or you want to proceed well, propria persona or sui juris, I believe, right? And now I will give you the different definitions for those. All right. I or elects to proceed pro se, which is without a lawyer, blah blah blah. All pretrial motions shall be served or filed within 45 days after arraignment and before commencement of trial, or within such additional time as the court may fix upon application of the defendant made prior to entry of the judgment. All right. So remember, 45 days after arraignment. So all pretrial motions shall be served or filed within 45 days after arraignment. So you got up to 45 days to file all your motions. All right. So all pretrial motions with supporting affidavits, affirmations, exhibits, and memoranda of law, whenever practicable, shall be included within the same set of motion papers. So if you file a motion to dismiss, make sure you have the motion, right, that you're filing, along with the affidavit, and you also want a memoranda of law with that as well. Now, I ain't gonna, I ain't gonna, go into all that. Show you how to do a memoranda of law, show you how to do an affidavit, or show you how to caption a motion as well. I mean, I might. I mean, the video's already at an hour. You feel me? I mean, oh yeah, you could do your research and find the structure of a motion. See how the caption, everything, how the paper's supposed to be, and all that. I'm just showing you, you know, the laws to use when filing emotions and how all this or the form. So when you file your motion, you want to support an affidavit with it and a Miranda of law, most definitely, right? You want the motion, the affidavit, and a Miranda of law, right? When you filing your motion, all right? Let's continue. All right. God damn. What the hell? Prosecution of informations. Pre-trial proceedings, I believe this is, right? Is it? Pre-trial proceedings. God damn. Yo, what's really good? Proceedings in the Superior Court. Oh, grand jury and its proceedings. All right, there we go. Let me see. Nah, it's not this. Or is it? All right, nope, it's not this one. All right, there we go, right? Motions. All right, so it's in proceedings in Superior Court from filing of indictment to plea, right? So these are all your motions you want to do. So you want to file a motion to dismiss indictment, defective grand jury proceeding, right? And in furtherance of justice. We could do that. Or you could put indictment is defective as well. So you want a motion to court to dismiss based on the indictment being defective and the grand jury being defective, right? And I already told you how the grand jury is defective, right? And I already told you how if the grand jury is defective, then the indictment is as well as it is defective as well. So here's the procedure for that, right? 210.45. Let's go all the way down. All right, let's go to the defective indictment, right? So an indictment or account thereof is defective within the meaning of paragraph A of subdivision 1 of section 210.20 when it does not substantially conform to the requirements stated in Article 200, right? Provided that an indictment may not be dismissed as defective but must instead be amended where the defect or regularity is of a kind that may be curbed by amendment pursuant to section 200.70 and where the people move to so amend. The allegations demonstrate that the court does not have jurisdiction of the offense charge or the statute defining the offense charge is unconstitutional or otherwise invalid, right? So let's go to right here, right? Let's go to 200. All right, let's go to 200 real quick. 200. Oh no, hold on. My bad. All right, 200 will be right here, right? Indictment. And the definition of indictment. So, in order for indictment to be not valid, right, an indictment is a written accusation by a grand jury. So, if the grand jury is defective, the indictment is defective. So, it does not conform with this definition, right? Because an indictment is a written accusation by a grand jury, right? So, it does not meet the definition if the grand jury is defective, right? Or filed with a superior court. It does not meet the definition, right? Requirement of the definition if it's not of a court. And we know what court means under New York, right? It got to be of a judicial function. It got to have judicial power, right? Which none of these criminal courts do. These criminal courts do not have judicial power, all right? So that's what you need to understand. All right, moving forward. Defective grand jury proceeding, right? Well, hold on, let me see. Let's go back, right? So the indictment is defective, right? Now, motion to dismiss or reduce indictment on grounds of insufficient of grand jury evidence. Motion to inspect. No, we don't want that, right? Right, there, defective grand jury proceeding, right? The grand jury was illegally constituted. Right? We already know that the proceedings is conducted before fewer than 16. So even when you request to be at the grand jury, yeah, count the jurors. Make sure there's at least 16 of them motherfuckers. Excuse my French. Cause if there's hold on, fewer than 12. If there's fewer than 16, you feel me? Yeah. Illegally. That's the yeah. But that's only if it's not illegally constituted. Because we could get them, because, yeah, the grand jury is illegally constituted because in order for a grand jury to be constitutionally impaneled, it must be of a superior court. To use the word court, right? You got to be of a judicial function. The court got to be of a judicial function, right? So a court that's not of a judicial function that's impaneling a grand jury is in violation of the Constitution as well, your due process, right? All right, but we ain't gonna get to that. We just gonna get to the uh, the proceedings and the criminal procedure law. So we know that the grand jury proceedings is defective because it was illegally constituted, right? Because only one of a superior court, right, could be legally constituted, right? Or fewer than 12 grand juries concur in the finding of the indictment. We don't even know how. That's crazy. In order to find out if more than 12 didn't concur, you got to be there. So with that being said, you know, if you there, and the grand jury, you gotta make sure you there when the grand jury is making a how should I say? I guess damn, catching a brain fog at the moment. You got to make sure that the grand jury when the grand jury is voting, you got to make sure you're there. See, I ain't gonna give you too much information about what I went through, but yeah, the fucking DA kicked me out, bro. Yeah, the DA kicked me out. This was my first time, in a situation the DA kicked me out. I think I was supposed to stay in there and see all of them vote. My dumb ass didn't even count how much grand jury was there. But it doesn't matter. It didn't even matter. It didn't even matter because it's always, too many ways to skin this cat. Yeah, it's too many ways. But anyway, moving forward. So yeah, grand jury defective and indictment defective because they're not of a judicial function, so they can't use the word court. And a grand jury only could be impaneled by a superior court. All right. So yeah, you got that right. So let's get to it, right? Let's get to the Constitution, United States Constitution, uh, uh, the Fifth Amendment, right? Fifth Amendment. This is what the Fifth Amendment says, right? Uh, protect citizens from self-incrimination, double jeopardy, and the government taking private property without just compensation. What else? Due process. Citizens cannot be deprived of life, liberty, or property without due process of law. Due process includes procedural due process, right? The procedures, and requires fair and impartial hearings, right? And substantive due process, which protects fundamental rights not listed in the Constitution. Grand jury, right? It got to be a grand jury. A person charged with a crime that warrants a grand jury, right, can challenge members of the grand jury for bias. So, for instance, right, a grand jury, we already know, must impanel, in order to impanel a grand jury, it must be of a superior court, a Supreme Court, right? And we know in order to use the definition of court, it got to be of a judicial function. So it cannot be a superior court if the definition of court can't be used, right? So yeah, the grand jury is defective in violation of the Fifth Amendment. And if the DA is in violation of the Fifth Amendment, that means he's in violation of his oath. Yeah, we could get him for his oath, right? Yeah, among other things, operating right. We could get them for this too, as well as I stated in the other videos, in the how to maintain your sovereignty video, 18, right? USC 1, yeah, by summoning you or by giving a writ, talking about a grand jury, a proceeding for a grand jury is pending, right? They giving, makes or use any false writing or documents, knowing that the same to contain any materially false, fictitious, or fraudulent statements or entries therein, right? They giving false materials, right? So anyway, unauthorized legal proceedings, right? So yeah, we can get them for all this, man. All right, damn. I don't want to go too far. I could go for days on this. All right, so I'm gonna leave this here. I'm gonna conclude here, man. So this is how you can motion the court, right? This is how you can motion the court. Now you gotta make sure you're using a procedures, right? All right, so here's another thing, right? Let me see. Because in order to file motions, it gotta be filed after the arraignment, right? So in a superior court or a county court, your arraignment comes after you are indicted. Or you could file for a special judicial hearing, right? With a judicial officer, right? But you gotta know how to request that. Now the unified court system got their own rules, for governing. Like, yes, you got the criminal procedure law, but then different states also got their local rules. So you got to know the local rules as well. You got to read the local rules, but the local rules always got to be in compliance with the uniform rules, and the uniform rules is the criminal procedure law. But I believe. Well, no. The unified court system for New York State as well, everything is unified. So they got rules for county and superior courts that's different from local courts. All right. So the unified court system got rules for county and superior courts, and then I believe they use the criminal procedure law as the guide for the local courts. So man, I could say I got a lot more I could say. You feel me? But I'm gonna conclude here because I feel like this is really enough. But you know what? Before I conclude, I'm gonna give you another jewel, right? When it comes to traffic tickets, right? It's gonna say the state of, and the state gonna be in capital or a capital S. Now, let me let you know something, right? Unlawful imprisonment, right? Unlawful imprisonment, also known as false imprisonment, is the act of detaining someone without their permission or legal authority. So when a cop pull you over for a traffic ticket, they are detaining you. Yeah, they're in violation of this law right here. Yeah, they're in violation of penal law section 135.05. Yeah, we could get them for that too. Why not, right? Yeah, for restrains another person's movement. Yeah, it occurs when someone intentionally and unlawfully restrains another person's movement. And that's exactly what they do by detaining you without authority that they perceive under the color of law. Yeah, we could get them. And then when they issue that citation, that's evidence right there. Yeah, let's get them. And, and you could file a well, I'm gonna show you how to file an Article 878 special proceeding. But that's for a different video. But yeah, we can sue their ass, man. Why not? Yeah, sue them, get them for everything, break the bank. Yeah, we got to start breaking these banks, man, because they making a lot of money that belongs to us. We gotta get them. So I'm gonna conclude here. Stay vigilant, and you'll prosper. Peace and love, man.